Well, ladies and gentlemen, we are immensely privileged to have, and I'm especially honored to introduce the Honorable Madam Justice Linda Chan to deliver the lecture this evening, Hong Kong as an International Insolvency Hub. Madam Justice Chan has been the judge in charge of the companies in bankruptcy list since August 2021. This is arguably the most intense and difficult list in the High Court. I certainly think so. She has been the judge in charge of many high-profile, difficult cases, among them the Evergrande liquidation. For those of you who like to read cases, read her judgment in Re China Evergrande Group. She also wrote the extremely important judgment regarding cryptocurrency in Re Gatecoin Limited in liquidation. Before joining the judiciary, Linda Chan SC, as she was one of the most respected and successful company law barristers we have ever seen in Hong Kong, and that's not an exaggeration. The community and the judiciary, not to mention the then Chief Justice, or whoever he was, were extremely fortunate that she gave up her lucrative career as a barrister to join the bench. I would add here, in the best traditions of the bar. When commerce and finance flourish, this success is driven not only by natural persons, but through those legal persons we know as companies. The heavy workload of the Hong Kong courts testifies to the protection of the legal rights as well as the incurrence of liabilities on the part of all those who are connected to companies, those who deal with them commercially, their investors, creditors, shareholders, and directors. This protection consists not only in the adjudication of commercial disputes involving companies, it also involves the courts ensuring that companies operate internally in a proper way. The internal discipline of companies is what is generally known as company law. It is vital that companies have this internal discipline. A quick look at the company statutory structure in place in Hong Kong confirms this. The other side of the coin to finance and commerce flourishing is when businesses fail. The legal issues following the collapse of companies is as complicated as those when these companies are successful. In many ways, these issues are more complicated. Often, of course, a lot of money is at stake. The rights and liabilities of the same persons I've just identified also have to be resolved by the courts. Following the collapse of companies, there is often confusion, if not chaos. If there is to be a fair and proper distribution of the assets of a failed company and the proper establishment of liabilities, there must be order. This is where the insolvency regime takes over. The integrity of the financial and commercial structure of the community is, I think, reflected in how both success and failure are handled, and in how orderly a process is when we're talking about insolvency. In this lecture, Madam Justice Chan examines and analyzes Hong Kong's insolvency regime. It is a very sophisticated one, and one that is essential to understand for anyone who has a stake in Hong Kong as a major financial center. May we please welcome Madam Justice Linda Chan.
Thank you, Jeffrey, for the very kind introduction, and thank you for the Institute and Hong Kong U for inviting me to this lecture so that I can share with all of you on some of my thoughts on the issues coming to the companies and the bankruptcy court which are issues which I tend to think that they're also very relevant to everyone who practice in the law, not only because when the companies are thriving and doing very well, then there will be dispute among shareholders, but also when the companies go under and become insolvent, and we'll have a dispute coming to our court, and that is also where we play an important role in this area. Now, the topic is Hong Kong as an international insolvency hub. Perhaps I'll just give everyone an overview of what exactly we are talking about. Now, just to give you some context, by August 2024, in Hong Kong, there are over 1.4 million Hong Kong companies. By Hong Kong companies, we are referring to companies that are incorporated under the Companies Ordinance. But that, of course, many of them include companies which are either wholly or partially owned by foreign entities and foreign investors. Because even, for example, during my practice, we see that we have, I acted for clients coming from Africa, America, Europe, and very different jurisdictions. And they all make use of Hong Kong company to hold their investment or properties or assets. Principally because of tax reason and also because of the relatively free regime, which normally, I think most of the commercial activities like transfer of shares, transfer of assets, when the companies are solvent, then they are not matters which will be regulated. And so for those reasons, we see that there are many foreign investors coming to Hong Kong and then use Hong Kong companies to hold their investment, and also in the form of joint venture. And then we also have what we call the registered non-Hong Kong companies. And according to the statistic provided by the company registry, those registered non-Hong Kong companies come from 84 jurisdictions. And those are really companies incorporated in other jurisdictions, that is other than Hong Kong. And that would include, for this purpose, companies established in mainland China. And that because those companies, they have carried out or they plan to carry out certain more substantial activities, normally in the form of carrying on business, then they would invariably have to maintain a principal place of business or a place of business, and then our ordinance requires those companies to be registered as registered non-Hong Kong companies. And then we also have the third type, which is what we call the unregistered company. I put it in quotation because that is what the ordinance refers to. But rather confusingly, in fact, under our ordinance, Cap 32, the unregistered companies actually also include registered non-Hong Kong companies. And it is because under our former companies ordinance, that is the term that we adopted. But you have to bear in mind that when we are talking about unregistered company, we are really talking about foreign company, whether they are registered or not registered under our companies ordinance. And that's why I make the point that those companies, typically they simply carry out property or investment holding activities. In other words, they normally do not carry out any profit-making or revenue-generating activities, such that they do not need to be registered under Part 16 of our companies ordinance. And then another point I wish to highlight is that, in fact, there are over 333 mainland companies listed on the main board of our stock exchange, and their total market capitalization as at August 2024 is Hong Kong dollar 6.7 trillion, which account for over 50% of the total capitalization of all the companies listed on the main board. And I highlight the point that in relation to all these companies, the Hong Kong court provide very important infrastructure to support their economic and business activities. And the dispute are channeled normally to the companies and the bankruptcy list, which is really part of High Court. But then the way our High Court structure is that for these type of proceeding, they would classify as special lists and be put under the bankruptcy and winding up list. Just a broad overview in terms of the legal framework, what we are talking about. Now, in terms of statute, we are really only looking at three main statute. The first is, of course, the Companies Winding Up and Miscellaneous Provision Ordinance that deals with everything concerning liquidation that include compulsory and voluntary liquidation. And then the second is sets of legislation. They are the Companies Winding Up rules. That is, of course, those rules which govern the regulation and procedure concerning winding up matters. And then the third set of legislation is the Companies Ordinance, which is what I have always been referred to as the Companies Ordinance. Now, and of course, the Companies Ordinance itself cover everything. That it would include basic matters from the date when the company is incorporated up to the internal management and everything, save and except winding up, which are covered by another ordinance, which is CWUO, as I defined in this slide. And then, of course, we also common law play a very important part in that it applies to how our court applies the statutory provision and to exercise our statutory power. In the later slide, we will come to, for example, how the court exercises the long-arm jurisdiction over foreign company when it comes to winding up matters. And then it also applies to matters preserved by statute, whether expressly or by necessary implication. A good example will be, for example, although we under our Companies Ordinance, we provide for statutory derivative action, but under the relevant section, we also expressly preserve the common law derivative action, such that, for example, you are still able to bring what has been described as multiple derivative action, which is not available under our Companies Ordinance, but because that is expressly preserved by statute, so that is also something which shareholders can make use of if they have matters which they would like to complain or make a claim either against the company or against the wrongdoer. And then the third main aspect where common law play an important part will be when dealing with new devices. The example mentioned by Jeffrey just now concerning cryptocurrency is one of those, because Hong Kong is actually one of the three jurisdictions which have to grapple with the important issue when a platform, an exchange platform, whereby the customers deposit their cryptocurrency has been wound up by the court. And then there are issues about the first and most important issue that needs to be dealt with is whether cryptocurrency is a property at all, having regard to its particular feature, and that we apply the common law principle and ask ourselves whether cryptocurrency by its nature meet the three condition or necessary requirement to be classified as property. And for those purposes, we apply the common law principle, and then we come to the conclusion that the cryptocurrency, albeit as a new device or a new form of asset, generally recognized by the commercial world, we come to the view that it meets all the requirements of property and therefore can be regarded as property being held on trust. And that, of course, is only the first part of the decision. And then what follows on will be, then we have to decide whether amongst all the creditors who have filed their proof of debt in the liquidation of the company, and there are thousands of them, and whether those we have to assist the liquidators in deciding whether those creditors, they have a right in rent over the cryptocurrency themselves, or that they are simply an unsecured creditors who is only entitled to proof and rent pari passu with the other unsecured creditors. Now, those are the type of issue which we have to deal with, and which the liquidators will have to make application to the court for good reason, because the last thing the liquidators want is to say, well, because of all these uncertainty, and not just in terms of legal question, but also factual issues. If the liquidators decide to go one way, for example, and accept cryptocurrency to be property, and then to make the decision and say that, well, some of the creditors, they have the property, they have the right over the cryptocurrency themselves, whereas others don't have. And then those decisions presumably will be challenged one way or the other. So for that purpose, they want the court to be able to decide those questions, have taken into account the submissions and the evidence filed not just by the liquidators, but also everybody who have interest and who have filed a proof of debt in the liquidation. And that is just an example of showing how common law also play a very important role in the legal framework. And then the focus of today's discussion is really on insolvency, and hence the next slides set out the what I consider to be the starting point and the very, very important point, which we always have to bear in mind, which is that winding up is actually the creature of statute. And I cited the, of course, the very famous ratio of Lord Diplock in AS and C&K Construction, and also Sir Richard Scott in BCCI. And they both emphasize and remind us that the only way to bring into operation the statutory scheme of winding up is by the court making a winding up order against the company. Now, that has some aspect, and we will come back to this point when it comes to recognition of, for example, foreign liquidation. In circumstances where the Hong Kong court also make a winding up order against the same company and have that liquidation be carried out as what has been described as ancillary liquidation, as opposed to a situation where we are dealing with a foreign company where the Hong Kong court has not made a winding up order against the company. Now, and I also, for completeness, highlight the point, which is the last point on this slide, that in fact, apart from dealing with a creditor's petition, which we are really dealing with insolvent company, the company's court also deal with what we commonly describe as just an equitable petition. And those are really shareholder dispute. And again, it's important to distinguish between these two types of winding up petition. Although if you look at the form of the relief sought, it's also winding up order. But the jurisdiction and also the principle applied by the court is very different. And one very important point is for creditor's petition, the petitioner has to prove to the satisfaction of the court that the company is insolvent. Whereas for shareholder dispute, the just and equitable petition is the other way around. The petitioner, in fact, has to prove that the company is solvent. For the obvious reason, it is only if the company is solvent, in the sense that its assets are more than sufficient to pay off all the debts owed to the creditors, then the shareholders can come to the court and say that I have interest, a real interest in the company, and I want the company to be wound up on the just and equitable ground. The locus issue is something which a company come to our court and feature in creditor's petition. Now, if you just look at the ordinance itself, creditors is just a very simple term. But the case law developed to say that in order for a creditor to qualify as a creditor under Section 179, subsection 1, the debt in question, we are really looking at the legal right of the creditors, who has a right to demand the company to pay, and the debt itself has to be of a liquidated sum, or a sum which can readily be calculated by simple arithmetic. And the third requirement is that the debt has to be due and payable, and is not subject to any bona fide dispute on substantial ground or serious dispute, cross-claim. The last requirement, the emphasis is really on this. If the creditors claim that the company owes a certain debt to this particular creditors and for which a petition is presented, if the company is able to point to what we call a bona fide dispute substantiated by evidence, then the normal course should be for the creditors to litigate that claim in the usual way by filing a high court action and then obtain judgment before they come to the presenting a winding up petition. Now, and then I highlight the point about right is the legal right, so that, for example, a recent issue which sometimes feature in the winding up petition coming to the court is that we can see that a lot of the holder of the bonds, sometimes they think that because I have in this bank statement issued by the bank or by the security company, an entry showing that I hold X number of bonds of this issued by this particular company, and therefore necessarily they assume that they have the right to present a petition. But in fact, that may not be the case, and very often that is not the case, because if you have to look at the if it's issued under an indenture or the contract entered into between the company and the relevant notes holder, one very often find that the creditor, in fact, does not have the right to present a petition, and the right to commence, including to demand payment or commence proceeding. The right is very often reserved to and can only be exercised by the trustee on behalf of all the bond and note holder, usually upon certain resolution passed by requisite number of the bondholders. And that is a very common and I think pretty standard feature in terms, if we are talking about the global notes or bonds that come to the court. But then there is an issue which I want to highlight here, is that there are actually divergence in judicial opinion in terms of whether such note holder or bondholder can be regarded as contingent creditors. It's fair to say that as far as the authority show, there are at least, I think, 2 offshore jurisdictions. I forgot whether it's BVI or Cayman, which come to one view, basically to say that, well, these note holder, if they're not the trustee, then they are not even contingent creditors and will have no right to present petition. And conversely, the other view is the other way around, to say that, well, these note holder can be regarded as contingent creditors. So I just highlight this particular point. I think the Hong Kong Court Deputy Judge Jenkinson also have make a decision on this particular issue. And again, I highlight that under the first bullet point, I highlight the requirement of creditors, but I also want to add that in fact, under the same section, creditors also include contingent and prospective creditors. And the important point to note that is they have locus, in the sense that if they can prove that they are prospective creditors, in the sense that they are owed a debt of less than 100 million, but that has not fallen due, such that it is a prospective creditor. It also have the locus, the right to present a petition, but they will have difficulty in proving actual insolvency of the company, which is the requirement for the prescribed by the ordinance before the court can wind up the company. And again, I will come to that point in the next slide. The other aspect I also wish to highlight is the secure creditors. Again, this is not something that you can find in the ordinance, but generally it just means that if you are fully secure creditors, you have no real interest, although you can say that you have locus, but you have no real interest in having the company to be wound up, because what is going to happen is that if the company is being wound up, then the creditors will be able to realize the security and and apply the proceeds for the purpose of repaying the debt. And therefore, such creditors, being fully secure creditors, will have no real interest in presenting the petition. And therefore, I make the point that if the debt is only partially secure, then the debt creditors can petition in respect of the unsecured portion. Sometimes we see creditors to say that although I hold security provided by the company, but I will give up the security if the company is wound up, that is also permissible. Now, insolvency grounds very simply means that, well, again, it's something which is prescribed by the ordinance, that the company is unable to pay debt. Very often we find that the creditors would want to rely on the presumption under section 1781A of the CWUO. Very often people will say, well, the company failed to pay the debt. But in fact, if you look at the section, payment is just one way of complying with the statutory demand. You can also comply with the statutory demand by providing security, for example, so that if for whatever reason, the company say that, well, I dispute the debt, but I'm able to provide full security for the debt pending determination of the dispute. That is, in fact, also a satisfactory way of complying with the statutory demand so as to avoid the presumption of insolvency. And I think this is what I earlier referred to, that if you are prospective or contingent creditors, you may have difficulty in proving actual insolvency, because for the typical creditors to whom a debt is presently due and owing, then it can simply serve as statutory demand and rely on the presumption of insolvency. And that would suffice for the purpose of seeking a winding order against the company. And then I make the point that generally it's sufficient for the petitioner to prove that the company is cash flow insolvent. Namely, that its current asset, which is defined generally understood as meaning asset which can be realized within a year, they are not sufficient to repay the debt presently fallen due, and that's what we call the cash flow insolvency test. And for the purpose of seeking a winding up order, that would be sufficient. And I highlight that there are actually three factors at play, and which the court have to balance and consider in the interest of relevant stakeholder. The first and the obvious one, of course, is to respect the rights of creditors, because they are the only person who have any real interest in the company. And then the protection of public, which is the general concern that insolvent companies should not be allowed to continue to trade. And expediency is really, this is where the role of court comes into play, because it would be unfair for the company to have the petition hanging over his head, such that the court will have to deal with the petition relatively speedily to ensure that the company will not have to have the petition hanging over its head beyond what is reasonable and necessary. On the other hand, if the company is insolvent and has no prospect of restoring its insolvency, then it should be wound up. Now, when it comes to restructuring, which is again something which often come to the court, and the company, although they say that I do not dispute the debt, but nevertheless I oppose a petition on the basis that there will be a restructuring if given time for the company to continue to pursue that restructuring. Generally, the court will require the company to demonstrate that there is a precise, credible repayment proposal with indicative timetable, if not a certain timetable. And then the company will have to provide evidence to demonstrate that it is really a concrete restructuring proposal has been prepared and that has been put forward to creditors. Again, the emphasis is on transparency and certainty. And then such proposal had the support of the requisite majorities of creditors. And then there's a reference to 75% in value or in over 50% in number. And that really mirrors the requirement under our statute, which I will come to in the next slide. And that if, also very importantly, if implemented, the restructuring will be able to restore the company to solvency. That aspect is also important because let's assume, let's take the example of sometime we see the scheme of arrangement coming to the court, that the company only proposed to restructure let's say 50% of the indebtedness of the company. And then they will say, well, ask the court to, and put that forward as a ground for opposing the petition. Now, but if the financial position of the company is such that, well, even assuming that the company is able to restructure the 50% of the indebtedness, but that is the company will not have the necessary financial resources to repay the liability in respect of the other 50% of the insolvency, then it would mean that the last requirement, namely that if implemented, it would be the restructuring would be able to restore the insolvency of the company. That is not satisfied. Then the court may take the approach to say that, well, if that is the case, then it will mean that the adjournment or the restructuring proposed by the company will not be something which would be of genuine utility, in the sense that it would be, even if given time, even with the implementation of the restructuring, the company will not be able to restore to solvency. So what's the point of having the petition be adjourned any further? And then earlier on, I said that, well, restructuring is normally done through a scheme of arrangement, and that is prescribed by section 670 to 674 of the company's ordinance, and court may sanction the scheme to vary the rights of creditors and bind all the creditors. And the reason I highlight this is, of course, this is not the only means to restructure the debt. You can also do it bilaterally and by agreement with the creditors. But sometimes, especially when we are dealing with listed company, we see that a lot of time they resort to scheme of arrangement is because there are a large number of creditors, and also a lot of time, more often than not, it's impossible for the company to be able to procure agreement from 100% of the creditors. So that they want to have, so long as they meet the requisite majority as identified in this line, and with the sanction of the court, so as to bind all the creditors. And that's the reason why scheme of arrangement is being used as a form of restructuring. Expediency, I just emphasize, I think most of us sitting here knows that just following the English court practice, in our court, we always have this Monday morning hearing when all the petition, winding up petition, bankruptcy petition, and nowadays also non-commencement order, in petition presented by the debtors themselves for their own bankruptcy, they're all listed to be heard at the Monday call over hearing. And then I make the point that the company's got it's very accustomed to dealing with and determining the issue with relatively short time frame. And again, the important point is even listed or substantial company may be wound up if there's no valid ground to oppose a petition. And then just give the statistic that in 2023, for example, over 560 new petitions have been presented. And it's our practice that normally they would be disposed of within 6 to 9 months, depending on the creditor's view. And the letter is important because after all, we are dealing with companies in which only the creditors have the interest. If they want to give more time to allow the company to proceed with the proposed restructuring, and if those reasons are valid reason, there's no reason why the court would insist on having the company be wound up. Now, this is just to show what we call a typical corporate structure. And that also set the background in terms of all the cross-border insolvency issue arises. Now here, firstly, I use China Evergrande as an example. You can see that, well, this is of course a mainland very substantial real estate company, and they all with most of the assets and the projects and the business they are carry out in the mainland China. But then the ultimate holding company incorporated in Cayman, the shares are listed on the main board of the stock exchange. And then underneath this company, because this particular company is very substantial, it also has two other listed company also listed on the main board. And I think the China Evergrande itself, the ultimate holding company, also hold a substantial interest in these two companies. So this is the what we call the offshore structure. But then, of course, there's also the flip side of what we call the onshore structure, which normally means all the companies established in the mainland. And in this particular case, the group itself actually has another Evergrande. I think the Chinese name is actually the same, also Hyundai, which is in fact incorporated in mainland China. And this particular company, of course, is outside the jurisdiction of our court. And the company which has been wound up is actually only this company. So it's just why sometimes when you read the newspaper or that there are some doubts which have been said about or confusion even as to why the Hong Kong court is able to wind up a mainland company. In fact, we are really dealing with the winding up of this company listed in Hong Kong. And then, of course, the relevance of the onshore and the offshore structure, again, in this typical corporate structure, is that we see that a lot of time these listed company, by that I'm talking about not just mainland listed company, but also other company, they usually make use of the listed vehicle for the purpose of raising funds, both by way of issuing new shares and very often nowadays also issuing bonds in the form of corporate or even individual bonds to bondholder. And all these activities, they are usually carry out what we call offshore, which means in either in Hong Kong or even in other jurisdictions. And therefore, when it comes to restructuring, a lot of time you see the reference to offshore indebtedness and the onshore indebtedness is because of this difference in the structure. And of course, this is just a simplified corporate structure, and which hopefully give the audience some background in terms of what we are talking about. And in terms of what I call the long-arm jurisdiction, is just to say that, well, of course, under Section 177 of the ordinance, we have a jurisdiction to wind up a Hong Kong company. But then under Section 327 of the same ordinance, we also have the jurisdiction to wind up unregistered company. And this is what I describe as the foreign companies incorporated overseas. And that would include registered on Hong Kong company. And all companies whose shares are listed on the main board, they have to be registered as a registered non-Hong Kong company, and therefore they would fall within this definition of unregistered company. And then I highlight that although the court does have this long-arm jurisdiction and have jurisdiction to wind up these foreign company, but the court would only exercise the discretionary power to wind up these foreign company if the three core requirements are met. And that is what has been described, explained in the CAM case, which is in fact a Yongki case, albeit that is in the context of a shareholder dispute, but there's a very useful discussion in terms of the nature of the court's jurisdiction under Section 327. And then recently I highlighted the case of Shandong Chunming case, and which I will talk about a bit more in the next slide. So the three core requirements, what is this? There's really a self-imposed constraint adopted by the Hong Kong court and also the same approach in many of the common law jurisdiction, which is to require the petitioner to satisfy the three core requirements before the court would exercise the discretionary jurisdiction to make a binding order against the company, which is prima facie outside the territory of our court. The first core requirements only needs to show that the company has sufficient connection in Hong Kong with Hong Kong, and that requirement is actually, I say, it's actually quite similar, and it's even more flexible than the center of main interest under the model law concept. And because it is really looking at connection, and that connection can be provided either because the company's management has been in Hong Kong, it carry out the fundraising activities in Hong Kong, or that the accounts have been prepared in Hong Kong, or when the company has financial difficulties, the negotiation have been carried out in Hong Kong. And of course, more importantly, if we are talking about listed company, then invariably those company, each of the director have to sign and agree to a set of undertaking to abide by the listing rule, and also to and that their conduct is also governed by the Securities and Futures Ordinance. And these are and that's why I make the point that if we are talking about company whose shares are listed on the stock exchange, normally the first core requirement will be satisfied. The second core requirement, it's a reasonable possibility of benefit to the applicant if the petitioner is wound up in Hong Kong. Now, if you look at the cases in the past, we are really looking at presence of assets, because the cases said that, well, what is the point of setting in motion the winding up proceeding in Hong Kong if this particular foreign company does not have an asset in Hong Kong? Because after all, we're talking about winding up of company, the primary purpose of which is for the liquidators to collect and realize assets for the purpose of achieving a power pass-through distribution of those assets to the creditors. But recently, our Court of Final Appeal in Shandong Chunming has relaxed that requirement to the leverage created by the prospect of a winding up petition. Now, Shandong Chunming case itself, I remember it's a Shandong company because I think I once acted for this particular company at the very early stage. And this particular company, it has dual listing, and the shares have, I think it has primary listing both in the Shenzhen Stock Exchange and also the Hong Kong Stock Exchange. And all this is actually, you can read from the judgment itself. And other than maintaining the primary listing and compliance with the listing rule and also the SFO, the company has no other asset within the jurisdiction. So at some point, there was in fact, a huge debate at the lower court below as to whether the second core requirement, which, as I said earlier on, is really looking at the presence of asset, is satisfied. And ultimately, when I think Mr. Justice Harris decided, and then the Court of Appeal and the Court of Final Appeal agreed that the leverage created by the prospect of a winding up petition suffices for this purpose. And then the third requirement is, of course, we have creditors present within the jurisdiction, which again is usually more difficult to comply with. And the next topic I want to talk about is scheme of arrangement. Earlier on, I said that, well, the jurisdiction to sanction scheme of arrangement is really based on statute. And again, if we are talking about foreign company, then to find the jurisdiction, we have to be satisfied that the company is a company which is liable to be wound up by the Hong Kong court. And again, so we are back to the three core requirement. which needs to be satisfied before the court consider that it has jurisdiction in dealing with whether or not to sanction the particular scheme of arrangement. And I make the point that there's actually no jurisdiction to recognize a scheme sanctioned by a foreign court. And I make the point that to contrast that position with the model law. Because if you look at the model law, a lot of which is they're actually dealing with access to court, recognition and assistance, et cetera, and et cetera. Those are really procedural matters. But on those matters, although Hong Kong has not adopted the model law as part of our insolvency regime. But if you look at the free call requirement, which I just described, you can see that at least in terms of access to court, and then later on I will talk about recognition and assistance, it's actually on par with other jurisdictions which have adopted the model law. But then the only difference is that under model law, and when I talk about the Sonic case in the next few lines, you can see that one important aspect of the model law is that it also gives the power to those courts which has adopted model law to recognize a scheme of arrangement sanctioned by a foreign court. Now, but we don't have that power under our ordinance. Now, and then I make the point to say that we need to seek the sanction from the Hong Kong court if the company concerned, they have creditors who are subject to the in personam jurisdiction of the Hong Kong court, or that the debts are governed by Hong Kong law. And of course, when there are creditors that albeit satisfy neither, but then nevertheless they are willing to participate in the Hong Kong scheme, so that once sanctioned by the Hong Kong court, then they will also be bound by the scheme. And then I make the point that the Gibbs rule applies in Hong Kong as in UK and the Cayman. Basically, the Gibbs rule, which is what I quoted here, it's just simply that if we are talking about Hong Kong court, we will only recognize a discharge of the debt which is governed by Hong Kong law if the scheme is sanctioned by the Hong Kong court. So that, for example, if we are talking about a Cayman Island company, and the debt is in question is governed by Hong Kong law, and you come to the Hong Kong court to say that, well, I have already obtained the sanction from the Cayman court in relation to this, all the indebtedness, including this Hong Kong law governed debt. Because in Hong Kong we apply the Gibbs rule, when you come to Hong Kong court, that Cayman sanction scheme will not have the effect of being able to prevent that particular creditors from coming to the court to take enforcement action or to sue the company in respect of the same debt. It's because of this Gibbs rule. Now, parallel scheme, again, is something which is quite common. When we're talking about parallel scheme, it usually means that there are a scheme of arrangement, almost identical term, which have been promoted both at the place of incorporation, and if we're talking about a company whose shares are listed in Hong Kong, then the scheme are also promoted, and for which sanction is also sought from the Hong Kong court, and that is what we call the parallel scheme. Usually it will be used by the company when the company has debt governed by multiple law which it seeks to discharge, is because of the Gibbs rule that I just explained. And then the creditors whose debt are governed by the foreign law, they decided that they did not want to participate in the scheme sanctioned by Hong Kong court. Now, again, I have earlier on explained, if those creditors, albeit, for example, their debt is governed by New York law, if nevertheless they decided to participate in the Hong Kong court sanction scheme, then that particular creditor will also be bound by the scheme, and therefore it will not then, in those circumstances, for the creditors to also go to the US court, for example, to seek recognition of the scheme. And I make the second point is that if the company has substantial debts governed by US law, normally it would also seek recognition of the scheme sanctioned by the after obtaining sanction from the Hong Kong court, and then they would seek recognition from the US bankruptcy court under Chapter 15 of the Bankruptcy Code. And I give the example of Sunic China Holdings, which I think is called Yongchong. Now, in this particular company is typical, because in that particular case, we are talking about a company whose primary business and the assets are located in the mainland, and it makes use of Hong Kong as for the purpose of raising funds, including issuing bond and borrowing loans, and also the shares are listed on the main board of stock exchange. And then this particular company, I go to the next slide. Now, you can see that from the first point that the debt which the scheme sought to compromise, it comprised of debts governed by New York law, 7.93 billion, English law, 29 million, relatively small as compared to the other debts, and then Hong Kong law 1.1 billion. We can see that in that particular instance, after Mr. Justice Harris sanctioned the scheme in question, which of course cover all these three types of debt, and then the company applied to the US court under the model law for recognition, which is what I mentioned, that under the model law they have this that give the court which has been asked to recognize a scheme sanctioned by the foreign court, which is this particular instance, that is the power exercisable by the US court. They would recognize and enforce a foreign scheme which complies. They only ask two main issues. One is that complies with due process to modify the debts governed by US law, and then that has been sanctioned by the court where the company's company is located. Now, in terms of first requirement, that's usually not an issue if it's a scheme which has been sanctioned by Hong Kong court, because the US court has dealt with by now quite a substantial number of schemes sanctioned by Hong Kong court for which the company would like to seek recognition from the US court. And then I highlight the point that in the judgment that the note of Mr. Justice Bentley of the New York court, his lordship said that the most important factor in determining COMI is the creditor's expectation, with the focus on regularity and ascertainability. And on the facts of that case, the overwhelming support of creditors for the Hong Kong scheme support the company's contention that its COMI is in Hong Kong. Now, and I think this is what his lordship said. So basically, just to contrast the point that, which is the second big bullet point, you see that his lordship recognized that although the company, it's a company incorporated in the Cayman Island, but because it conducted no business in Cayman, has no asset or creditors there, and has no office there, except a mail drop address, which is the usual requirement for companies incorporated in Cayman. You need to have a registered address, and usually that can be done through a registered agent. And then in addition, the debtor chose not to restructure in the Cayman Island, a potentially positive consideration given the Fairfield Century holding as to the time period governing COMI determination. So what is that Fairfield Century's holding? Basically, the US court says that the relevant time for assessing COMI of a company for the purpose of recognizing a scheme of arrangement is to look at the period before the application is lodged. So if we are dealing with company which is insolvent and for which the company has already spent, let's say, for example, a year or even more than a year in negotiating with the creditors for the purpose of securing the agreement, and subsequently putting forward a restructuring proposal, then inevitably, if you're looking at that period, then the COMI of that particular company, albeit that it's a Cayman company in this particular case, the COMI of that particular company would be in Hong Kong. And that would be that was held to be sufficient to rebut the presumption that the debtor's COMI is in the Cayman Island. Now, and then the other aspect is about recognition of foreign liquidation. And I just highlight the point that under common law, there is a power to recognize and assist foreign insolvency proceeding. Earlier on, I make the distinction to say that it's important to recognize what we are talking about. If we are talking about a company, a foreign company, which has already been wound up both at the place of incorporation and as, for example, at the Hong Kong court, then there's really no need to resort to this recognition of foreign liquidation, because invariably, once the winding up order has been made, then you can bring into operation the entire statutory regime under Cap 32. So it will not be necessary to seek recognition of foreign liquidation. Because for the obvious reason that the ancillary liquidation of this particular foreign company has already been commenced in Hong Kong. And then I'll just highlight the point that Hong Kong court would assist the foreign proceeding, and that would include a foreign winding up proceeding commenced in the mainland for that purpose. We look at three factors. One, the insolvency proceeding is collective insolvency proceeding. And two, those proceedings has been carried out at the company's center of main interest. And then the three, the assistance is necessary for the administration of the company's winding up or performance of the office holder's function. And lastly, and just as importantly, is all the sort is consistent with the substantive law and public policy of the Hong Kong court. Just highlight the point that when just very as a sort of broad overview, when it would not be necessary to seek recognition is, for example, if we are really talking about foreign office holder, whether it's bankruptcy or winding up, they want to commence proceeding in Hong Kong, it's probably not necessary to to ask for recognition and assistance, because you can simply commence the proceeding in the name of by exercising the right as liquidators, which the liquidators have under the foreign liquidation, and then commence proceeding. And if the authority is challenged, then you can simply produce the relevant document to show that the liquidators have been appointed by the court of the place of incorporation of company, so as to prove that it has the proper authority to commence proceeding. And I highlight the point that it would usually be necessary. A lot of time is because the third parties, usually the banks, which hold the assets and documents of the company, they did not comply with the request made by the foreign liquidators, and then they insist that the liquidators will have to obtain recognition and assistance order from the Hong Kong court. And I highlight the point that the state of legal proceeding against company, that we have the Hong Kong court will have the power to order what has been described as a case management stay, rather than a stay under Section 181 or 186, for the obvious reason that if the company has not been wound up, then those provisions will have no application. And then hence I make the point that if substantial affairs of the company have been conducted in Hong Kong, it would probably be prudent to seek winding up order from the Hong Kong court and then carry on as ancillary winding up, so as to obtain benefit from the entire scheme under the CWUO. And then again, in a lot of the conference I attended, sometimes we talk about, what about the potential conflict between the statutory provision under the primary and the ancillary winding up? And I want to highlight the point that, in fact, those conflict and the inconsistency, they are matters which can be and have often been managed and resolved by appointing the same person as liquidators. And then with the liquidators appointed in both winding up, entry into protocol and to seek sanction from the respective supervising court in relation to those protocol. And then last topic is about the cooperation mechanism with mainland, and this is pursuant to the arrangement which has been in place since May 2021. And that is the arrangement between the Supreme People's Court of mainland China and also Hong Kong, the Department of Justice. And the assistance, the arrangement is to provide assistance to assist the Hong Kong appointed liquidators to take over property and document, investigate into the financial position of the company, manage the affairs and business of the company, and perform other duties allowed by the mainland court. I just highlight, probably I think most of you will be fairly familiar, that so far the arrangement as far as mainland is concerned is only confined to 3 pilot areas in Shanghai, Xiamen and Shenzhen. And out of the 18 specialized bankruptcy court in the mainland, although I'm given to understand that in fact in every city or province there are courts which will deal with bankruptcy, they call bankruptcy in the mainland, albeit they're not called bankruptcy court. But then these 18 bankruptcy court, they are really specialized bankruptcy court created to deal with the substantial caseloads of bankruptcy matters. And then I just highlight the point that the pilot court would recognize and assist Hong Kong insolvency proceeding, which is actually defined to include not just compulsory winding up, but also voluntary winding up and scheme of arrangement. And the only requirement is you have to satisfy that Hong Kong has been the center of main interest of the company for 6 months, and that the company's principal asset or place of business is in the pilot area. And then I give reference to the cases where the Hong Kong court approved the approve and issue letter of request to the court in the mainland, in the pilot area. And so far, the Hong Kong court had issued 8 letter of requests, 4 of which have been recognized by the mainland court. But I think the rest is not that the mainland court have refused to recognize. I think it's just that they have, at least as far as my understanding is concerned, it has not yet been approved. And then lastly, it's the flip side of the coin under the same arrangement, recognition by our Hong Kong court. Very simply, we apply the same principle that I have discussed, that we apply the same principle for recognition of other foreign liquidation or bankruptcy proceeding. And then because the arrangement really only set out the procedure. And then the recognition and assistance, as far as Hong Kong court is concerned, is not limited to the court in the 3 pilot area. And that so far, I think the mainland court have issued 4 letter of requests, all of which have been recognized by the Hong Kong court. Usually, I think between 1 to 3 months. Thank you. So those are all the points I wish to share.